Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today.
Hunter Biden has been found guilty on all counts in his gun trial, federal trial in Wilmington, Delaware.
You see how the media did that? They added up the two 10-year terms, and then they added 5 years for the other term on it, and they came up with 25 years in prison. That is never going to happen. Let me explain. So Hunter Biden was convicted today on all three counts in his indictment, and I know there are a lot of people out there sort of dancing on the graveyard of Hunter's legal career. I don't think that's appropriate, and I think in this particular instance, there needs to be a little bit of compassion for the man who has been convicted here, because the conviction, it really will have a massive impact on his life. So two of the crimes here carry a maximum term of 10 years. One carries a 5-year maximum. The sentencing guidelines, however, are going to take precedence over the statutes in this case. The interesting thing about the sentencing guidelines is they take a number of different factors, they plug them into a formula, and you wind up with a sentencing range between X months and Y months. And based on that range, the judge makes a determination about how much time you are going to spend, and in some cases, whether you're going to get probation. Now, again, the most important thing here is the fact that Judge Noriega is the one who is giving him the sentence. According to her judicial questionnaire, when she was nominated, she was a patent attorney in active litigation in Delaware. She has a master's in biology, and she graduated from Pittsburgh College of Law in 1993, actually the same year I did. One of the things that she's going to look at is the prior criminal history, and he doesn't have another prior criminal case that I'm aware of. Even though he had a history of drug abuse, and even though apparently he's bought more drugs than CVS, the fact is that he doesn't have a criminal drug possession charge or anything else on his record that I'm aware of. The factors which may influence the judge's decision here are, first of all, addiction. It's the most important factor, probably. The sentencing is going to have to take into account the overpowering addiction at the time of the crime. I don't think the guy was in his right mind when he went and did what he did. If he had been, he's a lawyer, he knows what the consequences are. So that tells me that something was essentially driving him that was different than a logical, rational mind. And so I'm convinced that the addiction part of this is going to play into how Judge Noriega winds up sentencing him. Now, the fact that he doesn't have priors, as I mentioned, is also going to be good for him. He has good family and good support system there in Delaware. He's likely to benefit from placement in a halfway house and extended probation with drug testing if that was an option. We'll find out more about that here in a moment. The sentencing guidelines take into account both the seriousness of the offense and the offender's criminal history. The sentencing guidelines provide 43 different levels of offense seriousness. The more serious the crime, the higher the offense level. So the base offense level, each type of crime is assigned a base offense level, which is the starting point for determining the seriousness of a particular crime. Most serious crimes have a higher base offense level. For example, trespass has a base offense level of 4, while kidnapping has a base offense level of 32. There are specific offense characteristics. In addition to base levels, there are characteristics that can be used to adjust that level up or down. For example, if you were not really active in the commission of a crime, well, you might wind up getting a level decrease. And those adjustments may include victim-related adjustments, they include your role in the offense, all of those kinds of things. Well, in this particular case, the only person who had a role in his offense is him. So I don't think there will be any adjustments in that regard. If the offender was a minimal participant, though, in the offense level is usually decreased by 4 levels. So I suppose it's possible to argue for a reduction in the offense level because of the addiction. Now, where there are multiple counts, as there are in this case, the sentencing guidelines provide instructions on how to achieve a combined offense level. These rules provide incremental punishment for significant additional criminal conduct. The most serious offense is used as the starting point, and the other counts are used to adjust the base offense level. Now, I'm not an expert on the federal sentencing guidelines, but we have count 1, knowing false statement, count 2, false statement to a federal firearms licensed dealer, and count 3, possession of a firearm by a person who's addicted to a controlled substance. Well, the base offense level is 14 because the 5-year sentence is probably a lot lower in the scale than the 10-year. I suspect this is only going to be enhanced by 1.5 levels, so that's going to put it in level 15. He is in the first column, which is no prior criminal history, which would put him between 18 and 24 months. But if he gets an enhancement for something, it could go 24 to 27, and if he gets a reduction, it could go between 15 and 21. The final step in determining an offender's offense level involves the offender's acceptance of responsibility. And basically, that you get a little bit of a break if you admit that you did wrong and you're sorry and you express remorse. Normally, however, there's only an acceptance of responsibility when you plead guilty. Hunter did not plead guilty. He pleaded not guilty. He took it to trial. And as far as I know, he hasn't accepted responsibility for anything. And he may not, because he's probably going to appeal his conviction. Now, the guidelines assign each offender to one of 6 criminal history categories based upon the extent of his past misconduct. Here, criminal history category 1, the least serious category, is for first-time offenders, and that's what Hunter is. There are no paroles in federal prison. Normally, you go in for an 18-month prison sentence. You have to serve at least 12 months, and then the last 6, you're in a halfway house on work release trying to be reintegrated into the community. But here is something that's important, and that is the Comprehensive Crime Control Act of 1984 makes probation a sentence in and of itself. Probation can be used as an alternative to incarceration, provided that the terms and conditions of probation can be fashioned so as to meet fully the statutory purposes of sentencing, including promoting respect for the law, providing just punishment for the offense, and achieving general deterrence and protecting the public from further crimes. But unfortunately, probation is not available for gun crimes. So it is fairly unlikely that he will get a probationary sentence. However, I do think that whatever the base offense level that they wind up determining, because it might be less than 14, it might be more than 14, it just depends on how the judge calculates it. Whatever that is going to be the starting point for the sentence. And my guess is that if the base level is 14 and it's between 12 and 15 months, then he's going to get 12 months. If it's the next level up, then he's supposed to be between 18 and 27 months, he'll get 18. And I think the reason that will happen is because of the addiction. There will be people who say that any softness in the sentence here is a result of political maneuvering. I don't think that would be the case. I think this judge has played it straight down the middle, all the way down the line. And we will just have to see what happens at the sentencing hearing. That hasn't even been set yet. But I would urge those of you who are so inclined to say a prayer for Hunter Biden, because he has a terrible drug addiction problem, and he will never be free of that. That little devil on his shoulder is going to be there whispering in his ear the rest of his life. Boy, it would feel really good if you could smoke some crack. And because of that, because he knows and understands and feels the intensity of that, the history that he has with that drug, he's always going to be battling that. So a prayer on his behalf, I think, is probably warranted. I believe very strongly that we need to punish criminals. Don't get me wrong. But we also need to realize that once a criminal has been punished, you got to let them up off the floor. You got to put a hand down and help them up and help them make their way. Now, he is not going to be able to practice law, obviously, while he's in prison. Although he may wind up helping people with appeals, I don't know. Sometimes lawyers who are sent to prison do that. Obviously, they can't practice law, and obviously they should not practice law while they're in jail, but sometimes they do. In fact, John Grisham actually wrote a book about that, where the judges there were 3 judges who were sentenced to prison, and they were all helping the people in their jail, get relief from their sentences. But I don't think he will be able to practice law when he gets out. The first thing he will have to do is establish that he has good moral character to be allowed to practice law again at some point in the future. He will probably have to retake the bar exam. He'll probably have to take the professional responsibility exam. He may have to jump through additional hoops in order to get his law license back. He may have to consent to random drug testing. He may have to consent to someone looking over his financial books. There are all kinds of additional things that can be done to help somebody as they re-enter the workforce as an attorney. But I think the biggest impediment to him being effective as a lawyer at this point is just who's going to hire him, given his past. We'll have to find out. But anyway, I don't think it's appropriate for people to be dancing on his career's tombstone or on him personally. I think that's unseemly. I feel sorry for the man. Going to jail is no picnic. They make it that way for a reason, of course, but it isn't easy, and it takes a lot out of a person when they go to jail. So my belief is that at the end of the day, we should be thankful that the justice system worked in his case, that the jury reached a verdict, and that he had good counsel to assist him. I'm sure they will do their very best to get as light a sentence for him as they possibly can, and hopefully that his family will help him deal with his demons with regard to addiction. That's what I have for you today. Thank you so much for watching. If you have the opportunity today, do something kind for someone. I don't know what to tell you to do, but you will find a way if you want to do something nice for somebody. And then when you have, come on back down here tomorrow, catch me at the beach, and we'll talk about something else interesting and fun. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.